If your insurance claim has been denied, then this is for you. Welcome to the Policyholder Podcast. My name is Danielle Snell and I'm the co-founder and managing partner of Elit Lawyers. Each week we meet with legal experts and industry insiders to delve into real-life cases of insurance denials, discuss common trends and patterns, and talk about strategies to navigate insurance issues. Whether you're a policyholder seeking to challenge an insurance declinature or a legal professional seeking to navigate the complexities of insurance law, this podcast will provide practical steps to help you take that next step. The Policyholder Podcast starts now. Today we're delighted to introduce Gabi Crafti, Senior Counsel, a senior barrister specialising in insurance litigation. She has a particular focus on insurance law and various aspects of financial services law. Gabi has appeared in some of Australia's largest and most complex legal disputes. And Victoria Blidman practices in a broad range of civil and commercial matters at the Vic Bar. Prior to joining the bar, Victoria completed her graduate training at DLA Piper and practiced as a litigation in their litigation and dispute resolution team. Delighted to have you both here today. Welcome, Gabi and Vic. Gabi, can I ask, to start off with, this podcast is obviously designed for policyholders, so we're wanting to create awareness to teach them more about the different elements involved in an insurance dispute. To start off with, what would you say are the key components of an insurance policy?
That's such a good question because you would never think about the components of an insurance policy unless you had to start wrangling with one.
Yes.
I suppose if you were to look at a standard one, you would at the beginning usually see some kind of introduction.
Mm-hmm.
That introduction is not usually part of the insurance contract. So if I just take a step back,
yes,
an insurance policy is a contract between the policyholder
yes,
and the insurer. And so it's important to understand that the policy is precisely that. So what you're looking at then are terms of a contract, and the terms are, the primary one is the insuring clause.
yes.
And that may not necessarily be straight after the introduction,
mm-hmm.
but it will be readily identifiable. So that's the number one component.
Yes.
The insuring clause sets out the extent of cover.
Mm-hmm.
And then what follows will usually be a raft of exclusions that chip back at that insurance cover, and conditions on claiming, conditions on cover being granted.
Mm-hmm.
There'll be definitions at somewhere in the policy, sometimes at the beginning, sometimes at the end. There'll also be a schedule, and the schedule will set out the details that are unique to that particular policyholder.
Mm-hmm.
So, for example, should include the policyholder's identifying features, as in name,
mm-hmm.
Any particular aspects that have been negotiated specifically for that insured, like
Yes.
limits of liability.
Yes.
And we can come back to what that might mean.
Yes.
And then what you might also see as part of the insurance policy document, sometimes you'll see what are called endorsements,
Mm-hmm.
and perhaps we can go into what they are a bit later. And I've probably forgotten something else. And
no, I think you've done that
Yes,
very
I
well.
covered.
That was pretty comprehensive.
And for the benefit of policyholders, I think often they'll just review the schedule or the first couple of pages, but attached to a policy is often also a product disclosure statement
Yes.
that can be upward of 100 pages sometimes. And then there's the policy wording, and then there's also the policy schedule. So there are a number of key insurance documents, aren't there, Gabi? And would you agree that the devil's in the detail? And
Absolutely, yes,
Yeah.
I would.
Yeah.
One of the things I think policyholders misunderstand is that and the relationship with the insurer is governed by the terms of the policy and not much more.
Yes.
I say not much more because there is legislation as well, and there is the common law, but primarily the relationship between the policyholder,
Yes.
sometimes known as the insured,
Yes.
and the insurer, is governed by the contract. And so it is really, really important that when making a claim under the policy, the policyholder understands that the metes and bounds of that claim are going to be governed by what is in that document, or that suite of documents that you referred to, Danielle, and nothing really more. And the reason I say that is because I think back to a time when my mother-in-law had to make a claim on an insurance policy and she was denied cover.
Mm-hmm.
And she said, but I'm insured. And I said, well, what does your contract, what does the policy contract say? And she said, I've got no idea. And as it turned out, it did not cover her for what she thought she was covered for. You've got to read it.
You've got to read it. And just on that, Vic, maybe you can tell us, how do you think policyholders can more fully understand what's in the contract?
That's a really good question. So I think it depends on how you come to acquire the policy. So obviously, if you've got a broker that's involved, really use their expertise. They're there to give you that guidance. So ask the questions that, particularly if you're aware that there's certain things that must be covered or that you're particularly concerned about. Ask the questions up front. Am I covered for this? Give some, think about some worst case scenarios, for example.
That pertain to your business, right?
Exactly, especially if you know that you have a particular product that's involved in your business. Ask the question, is this excluded? If not, what do I need to be aware of to ensure that I've got coverage for this very particular aspect of what we do? And it, particularly with businesses, it can be very, very specific. I've seen matters that have come down to, a particular mineral being excluded from cover. And that happened to be a mineral that was, very important to this particular insured, and it found itself into an exclusion. So really knowing what's important to your business and then asking the questions up front, because it can be very difficult to just read it cover to cover and understand it completely.
That's really helpful.
And Victoria, would you say that, there's a multitude and a large suite of insurance policies out there? Think, car insurance, travel insurance. Would your advice still be the same in terms of for any real insurance policy?
Well, that's an interesting one. I think there is a different way to approach it, whether it's, your personal insurance versus business insurance.
Yes.
I think there's different things to consider in that. Because it's so broad, I think you're looking for different things. In the life insurance and TPD income protection space, there's some very specific things you'd want to be thinking about. And in that case, you're talking to usually a financial advisor that can give you assistance. Whereas if you're talking about your business, you're probably talking to an insurance broker to get advice at that early stage. So I think there's different channels depending on the type of insurance that we're talking about.
Yeah, thank you.
Gabi, what do you think are the most common reasons that disputes break out between insurance companies and the insured's policyholder?
Again, probably depends on context. And perhaps if we just take a step back for a moment and get really down to brass tacks.
Yes.
There are classically two kinds of insurance. There's general insurance and there's life insurance. Life insurance covers death cover, total and permanent disability, trauma insurance, income protection, and so on. General insurance tends to cover liability policies, and we can go into what they are. Liability policies and first and third liability policies, more business related. So what tends to go wrong, I think, is it can be a range of things depending on the circumstances. If we take, for example, life cover, things that tend to go wrong can include not disclosing pre-existing medical conditions where that is a
Yes.
requirement.
Yes.
Mhm.
Not understanding the extent to which you've got to make that disclosure.
Mm-hmm.
Not being fully forthcoming necessarily with the insurer.
Mm-hmm.
In respect of general insurance, there are myriad reasons. It's probably a bit
Sisters.
more diverse.
Yes.
And can often rest on exclusions and not understanding or not perhaps agreeing on the extent of cover or the extent of an exclusion of cover.
So that's the insurance company that, as you were saying earlier, that they've incorporated exclusions within the terms, and they say in the insuring clause, we'll cover you for this, but then the exclusions say, but we're not covering you for if any of these other things happen. And it all comes down to the specific event that transpires, doesn't it? And so often when they're writing these policies or the policies being incepted, it's unknown. It can be unknown. For example, the COVID pandemic, as an example, when we're just discussing business interruption insurance, it was unknown that was ever going to, occur. So there can often be such complexities with sort of understanding and analysing these sorts of contracts, can't there?
There can, and I mean there are lots of other examples as well. So evolving environmental conditions, like for example, flooding up northern Australia. The extent of flooding, for example, flooding of different rivers, different waterways. There actually can. I'm thinking now about an actual example in my relatively recent experience where the wording of the policy about what a waterway is can be absolutely critical. And you can't always, plan for everything in advance. You and sometimes even the insurers don't know how the policy will fit an actual circumstance until it happens.
When you were talking about the wording of the policies, often there can be ambiguity, can't there? And can you talk us through that? Like, what happens when, Vic, there's ambiguity and it's unclear how a certain clause should be interpreted? Can you talk us through the analysis and how the courts want to approach it?
Yeah. So I think the fortunate thing is insurance law has been around for a very long time, and a lot of the wording that you see in standard insurance policies, a version of it or very close to it has been considered by a case somewhere at some point. So most of your typical insuring clauses have and exclusions, there will be case law about that clause or one very similar to it, because all of these clauses that we find in these policies, they've not sort of just been thought up yesterday. They've probably come from something that was drafted, maybe 100 years ago and has slowly been tweaked over time. So we really can rely very heavily on cases and what's been determined before in relation to what it means. I think the ambiguity is one thing, but how that ambiguity applies to the facts of each case is really where where it becomes interesting. So we might know how this ambiguous term has been interpreted in one set of facts, but as often happens in a new case, you say, well, these facts are a bit different, and so this, although it was resolved this way, in this case it should be resolved a different way. So we lean heavily, of course, on the decided cases, and they assist us, and all the sort of principles that exist around contractual interpretation, because, as Gabby said, we're dealing with a contract, so you're applying your ordinary principles of contractual interpretation when you're looking at insurance policies, but we do have a wealth of sort of information and precedents that we can rely on to see how it should work.
That's a great explanation, Vic. And and maybe I'll open up to both yourself and Gabby, but in your practice as barristers, do you generally see that the cases that cross your desk are more in respect of declinatures or possible declinatures with insurers, or more so where there's a sort of a partial declinature where the insurer is sort of saying yes to some things but no to others? Is there a sort of a flavour that you generally see?
I see the full suite of it. So, and actually, for some of the larger clients and the larger claims made on substantial policies, solicitors who tend to brief me get me in early in the process to assist in writing the submission. So this is at the point in time when an insurer is sort of indicating we're considering declining this claim. When I get briefed early on, then I can help craft a really solid submission to the insurer to indicate, these are the legal reasons why you should be interpreting the policy in the way for which we contend. So it can be coming in really early at that point when the insurer is flagging, this is where we're heading, right through to the insurer has declined and the policyholder has said, right, well, I'm kicking off litigation to because you've breached the policy by declining my claim, and then we're off to court, and some matters do run all the way through to judgment.
Just on that, Gabi, I think it can often be underestimated, can't it, by policyholders or insurers, how important it is what they're telling an insurer or how they're putting their claim from the very outset. So if a crisis event's occurred, they're asked to answer a number of questions, that it is worth their while seeking to brief someone of your seniority at an early stage, because it is so important how they formulate the claim. If they say something wrong or something, it can often come back and bite them, can't it?
Absolutely. And look, I wouldn't necessarily recommending going to a solicitor and asking them to brief senior counsel for a claim that's it's got to be proportionate, but in the right degree of complexity or proportionality or quantum, it is recommended. There are, of course, excellent other barristers as well who aren't senior counsel, like, for example, Victoria, and getting someone like her involved early on as well, helping to draft a really solid, well thought through argument to the insurer can be highly effective.
And so you mentioned your mother-in-law before, Gabi, and she was declined cover, and she said, well, why? I have an insurance policy. In instances where a policyholder has been denied, or possibly the insurance company saying, we'll cover you, but we'll only cover you for this amount. We won't cover you for that much higher amount that they were expecting. What is a policyholder's options? What can they do? Where can they go? I mean, court's obviously one of the options, and we can talk about that. But can you talk us through any other options that they might start at?
Yeah, sure. So most policies have a process, like an internal review process. So that's usually the first port of call. And what that essentially does is sort of elevates the decision making up the sort of chain within the insurance company. So that's the first. Effectively, another person, it looks over it, and it's an opportunity for someone to make a fresh decision.
Just on that, Vic, have you ever seen an instance where it's gone through the internal disputes resolution process, so someone else at the insurance company is reviewing it and they've changed their decision? Because I've only ever seen it being reinstated in my experience. But have you ever seen that to occur?
Look, I haven't, but I always have assumed that that's because by the time a lot of the matters get to me, it's getting close to sort of either proceedings have been commenced or, we're on the eve of a trial. So I've always assumed that that's what I see. I don't know what the statistics would be and how that would go. I assume it might be similar with you, that the ones that are coming to you have probably been through that process.
That's
correct.
Right.
Yeah.
But we often see that it's a reinstatement of the original decision, and the reality is it's still the same insurance company that's
true,
making the decision.
Yeah.
But no, that's also, it's a very helpful process, because no doubt you still narrow the issues and you are putting forward the reasons why you say the policy should be covered, and then the insurance company, even through that complaints process, will explain to you or ought to explain to you the reasons why they've decided not to cover you. What are some of the other options?
There are some bodies, depending on what type of policy it is, that like a sort of a complaints ombudsman type authority that you can refer some policies to. So that's an option. But I think the most effective, and it's kind of coming back to where what Gabi was talking about, is actually if you've got a really solid point to make about why there's been an error, putting that forward in the most comprehensive way to the insurer with all the supporting documents if you've got them, and giving it as a sort of nicely wrapped up package that says, here you go, this is why you're actually not, why there's an issue here. I think that is going to be your most effective strategy, because generally, at least in my experience, insurers are not there to not pay valid claims. So if they actually get something that says, oh, no, there's an exposure here, or, this should be paid because it's covered, they will cover, they will pay. I find often there's a real, where the difficulty arises is that there's almost like a misunderstanding or an information gap, where there's information that the insurer needs, and perhaps the insured doesn't always understand why that's important. And so perhaps they're not handing it over, or they're sort of taking time to hand it over. And it's when that dynamic develops that you end up seeing more problems. Whereas I think time spent early on in really putting together quite a comprehensive submission that it really expresses the position clearly, it'll help get them over the line potentially, but B, I think if it does proceed, you've got something to give to your lawyers and to really set you off on the right path and to do it as efficiently as possible.
Now, that's really good advice, because there's often it's a communication barrier to some extent. And when policyholders come to us, isn't it, Jason? They might not understand. There's usually been a protracted history, and there have been discussions and negotiations between them. But policyholders are unclear as to why is the insurance company continuing to keep asking me for further documents. But
I like Vic's sort of wrapping it up all in a nice package. I think that's really important, because the time spent is loading it up and just putting it all neatly to the insurer. I think it just it sets policyholders up quite nicely, because you're sort of essentially now at that point in time essentially presenting your case. And insurers have they've got an obligation, but they also will consider it, I think, quite much more palatable to them. And so, they know where you stand, or the policyholders stand. I think that's quite helpful in trying to progress matters, efficiently and promptly.
That's right.
Yeah.
We do most of our work, all four of us, in the courts, but have you seen, Vic, this one might be for you, many insurance disputes go to AFCA, which is the Australian Financial Complaints?
Yeah, so I haven't seen it in any of my matters. I know of it. I know that people go out and do go through that process, but generally it's already been through that process by the time it's come to me, or it doesn't go, or often the policies that I'm dealing with aren't amenable to that, going down that path. So not one that I've worked with much. I'm not sure about you, Gabi.
I've acted for insurers in applications to the Federal Court for review of AFCA decisions.
Okay.
So they are respondents to applications for review. So again, at that point, it's already been through the AFCA process, and the policyholder was not happy with the outcome of that process, and so then sought review in the federal court, which is sort of for want of a better expression, an appeal right. So then in those scenarios, I've acted for insurers, not for policyholders.
Do you have any just general observations about AFCA, the authority, Gabi, just for any listeners, as to that it might be weighing up, should I go to AFCA or should I issue a proceeding in the courts?
I think I would recommend for policyholders to use that process before litigating. Certainly for the policies to which AFCA is applicable, perhaps smaller type claims, not necessarily for the multi-million-dollar claims, but for something less than that, yes, I would avail myself of that if I were a policyholder before litigating. It's certainly preferable. You don't close off any options by doing it, but you do have a relatively hassle-free process that way.
Certainly when we deal with policyholders, we look at what the quantum of the claim is, meaning the quantum, what is the amount in dispute? And if it, as you say, Gabby, is at the smaller end in terms of what the dispute is about, we would suggest AFCA, but we have also encountered jurisdictional issues with AFCA and resourcing issues and delays associated with that process. So there are pros and cons of each, whereas, when we're dealing with a court matter, then we also consider the proportionality as to legal costs. So, a policyholder will then start incurring legal costs, which typically, well, depending on the type of insurance, this might be another question for you, Gabby. There are certain policies that include claims preparation costs, aren't there? And then there are others that don't.
Yes.
And there are court authorities that have gone through the fact that claims preparation costs are not legal costs, so to speak. And it's what are claims preparation costs?
So claims
Gabby?
Preparation costs, and probably Danielle, you may be better actually to answer this question. But my understanding is that it's what it costs you to prepare your claim on the policy.
That's right.
So whether it's getting expert reports into building damage, for example, if it's a property insurance policy, having someone help you prepare your claim. Like loss assessing, that kind of activity, that would be covered by a claims handling cover.
Just on that, Gabby, in terms of claims preparation and submitting documents to your insurer, and you were talking about earlier preparing your submission, there's often a lot of work that goes into that. Often policyholders are unaware that they can seek out their own expert opinions, for example, quotations and opinions as to rectification scopes and the like. Whereas when they come to us, they're in a situation where the insurance company has gone out and hired all of their own experts. Do you have any observations in that regard? Do you think that more policyholders should seek out their own advice?
Definitely, if they're not happy with what they've been given by the insurer, absolutely. And I think you're right, and I hadn't really paused to reflect on that policyholders may well be unaware that they are entitled, of course they're entitled to investigate and put up a counterpoint, really, from an evidence base to what the insurer is proposing or relying on in making its decision.
And Vic, under the Insurance Code of Practice, I think policyholders can often be unaware what their entitlements are as well. So can you talk us through what they can ask insurance companies to provide, like information that they could ask an insurance company to provide versus what typically happens, which is the insurance company asking for all the information from the policyholder?
That's a really good point, because I think often the information flow can be one way, but as we know under the Insurance Contracts Act, the duty of utmost good faith is owed by both parties to the contract, and often the contract itself will will set out what the obligations of both parties are. So I always think it's funny because it's exactly where we started. Always start with the contract itself. The policy documents will tell you what your obligations are to each other, and that may involve obtaining information from the insurer. There's always tricky issues around that, because sometimes they may have obtained documents that might be subject to privilege, or there's those sorts of tricky issues. But I think if you need more information as the insured, you should always ask the question, and if it's not forthcoming, ask why,
That's good advice.
to understand. I think a lot of what happens in this space can be addressed by better communication and sort of much more, I think, rather than jumping necessarily immediately to heated communication, just really calm sort of information gathering exercises actually gets people a lot further down the track, because I think so much of the time you can resolve things by actually having a clearer understanding of what the position is. And then sometimes there's, a misunderstanding around why a particular exclusion is said to apply, for example, because a particular word is understood in a very particular way, particularly I think when we're dealing with technical policies or technical issues. People give different meanings to different words. And I think if you're always asking the question, well, why do you say this is the case? You'll actually learn more, and it'll put you in a better position to either explain and say, well, actually, no, that's not what this means at all. Have a look at this document or whatever.
Yep.
Or at least you understand what the position is better. And then that allows you as a policyholder to take stock and say, well, okay, now that I understand what this is, do they have a point? Am I at risk here? Yes, of course I want my policy to respond, but you've got to then start thinking through, is this the right thing? Is litigation the right path?
That's great advice, Victoria. And you sort of touched upon it just before, and you said, they've got duties of utmost good faith. Can you tell, for those policyholders listening out there, sort of what that really entails?
Yeah, so it's an obligation to act with honesty and candor with your insurer, and for the insurer to do likewise with the insured. I think a lot, at least insofar as the duties of the policyholder are concerned, a lot of their obligations, which is around disclosure, is now dealt with largely by the Insurance Contracts Act itself. You've got the sections that deal with the duty of disclosure. So a lot of that, but it continues on through the contract and through the life of the contract. So that means not withholding information if you think it might be, harmful to your chances of getting cover. You can't hold that back. And the reality is it comes out at some point. And so it's really important that policyholders are really upfront, and if there's documents to be handed over, they've got to be handed over. But likewise, the insurer owes a duty of utmost good faith to the insured, and that can apply to things like not arbitrarily denying cover, or not and delaying unreasonably in confirming cover or extent of cover. So all sorts of things can fall under that umbrella.
No, thank you very much for that very comprehensive explanation. Gabi, maybe this one's for you, but can you tell the listeners out there that sort of a memorable case that you had that you were successful in, preferably for a policyholder, but one that sort of springs to mind?
Sure.
I'm just thinking about, sort of lessons learned, as you go along, because there's a lot of, we do a lot of cases and you think, I should have done this or I should have done that.
Yes.
But, is there anything that...
Yes. Well, I mean, I can think of ones that have been successful prior to even getting to litigation, which I think for me personally is, I think, of most satisfying, because that's really what is of most benefit to the policyholder.
Yes.
I really won't bore your listeners with the details, because it is super intricate and detail oriented in a way that would just everyone would tune out, and I don't want that to happen to your podcast, Danielle and Jason. But it was for a major building company,
yes,
and it was making a claim on a policy, and being able to persuade the insurer that it had not interpreted its policy in the right way, in denying in flagging that it was going to deny cover, and really putting together a really solid submission on behalf of the building company to say this is why you're wrong with respect, and this is why you should construe the policy in the way for which we contend, and to have that be received considered and accepted. That was hugely satisfying for me personally, professionally, but for the client, it was they were quite surprised, not because they didn't believe in the strength of the argument, but because I think they were just knuckling down, ready to engage in mortal combat. And I think it is exactly as Vic said, that insurers, they're commercial animals in the sense that they're commercial creatures, and so they're not driven by emotion. They're driven by rational concepts. And so if you can rationally explain a position, they'll accept it where it's right, or where they can see that it could be right. So that's a really good example. But there are other examples of having been in court. I as a policyholder, acting for policyholders, I think I'd say I've only had partial successes. And in part that's because a lot of my work has been for insurers. And so, most of my court experience has been on the insurance side of things. Of late, that's changed or changing. But I think happily most of my policyholder work is dealt with and done and dusted before we even get to litigation. And I that for me is very satisfying.
And that's kind of the aim, isn't it?
That is the aim.
You don't want to, if you can resolve things early and pragmatically, that's the way you want to try and do it. And that's probably the take-home message. And
for me it is, absolutely.
And that's where that sort of that neat package, as we were saying before, that's where it sort of comes into play.
Just on that point, what we often do as well that I think is worth mentioning to listeners is that if we are approached by policyholders and we analyse the facts and we analyse the policy and we determine that they have a good case to challenge a denial by an insurance company, what we'll typically do, they've usually, as I said, already gone through quite a history. Instead of just issuing the court proceedings, we'll also can draft a statement of claim, and that's where we would brief competent insurance specialists, barristers such as yourselves, to prepare the court. It's effectively the court document that you would file, but rather than issuing it straight away, what we do is we prepare a letter, and it'll set out all of the reasons why the claim should be accepted, and then attach to the letter the draft statement of claim. And we send that to the insurance company, and we then invite them to a mediation or an informal settlement conference. And we typically find that for an insurance dispute where you are dealing, as you say, having acted for insurers a lot, Gabi, with they're sophisticated litigants, they're rational, they're not emotional, that we invite them to the table to have a discussion with us around why. And even if the case doesn't settle on that day, it'll typically narrow the issues. And then by the time we issue the proceeding, if we then have to issue it into the court system, we can then also tell the judge that we've already made attempts and look to have the case put on for a hearing as soon as possible, because that's the other identifying feature with these types of cases, isn't it? Dealing with a large insurer and policyholder, and there can sometimes be an unlevel playing field, can't there? And that leads me to my next question too. I'll direct this one to you, Gabi. When you're acting for a policyholder versus a insurance company, as a barrister, is it typically your job the same, or are you focusing in on different aspects, or is it different because you're dealing with a different sort of client in terms of the way that you communicate and analyse?
Yes and no.
I know it's a hard question.
That's a hard, yes. I mean, strictly speaking, there's no difference, but in reality there is. If you're dealing with an individual who's, say, for example, making a claim on a trauma insurance policy, absolutely the way I communicate with that individual, with my instructing solicitors there, will be different necessarily to, say, for example, if I'm dealing with an insured that is say, for example, a very large financial services provider with an Australian financial services license. The way I might deal with that outfit as a client might be quite different. But at the end of the day, the way I conduct myself is very much the same.
Yes, that makes sense. Yeah.
So, our job is to assist clients, but also as officers of the court, to assist the court to make its decision in the most efficient way possible. That is a primary driver for us in all of our cases. If I'm dealing with insurers as opposed to dealing with insureds, with insurers, they litigate, that they are very practiced at litigating, and so there's probably less explaining of processes to them. But similarly, I've acted for policyholders that also are very experienced litigants, and not because they're vexatious litigants. They're just they might be, for example, very large building companies or very large infrastructure companies, and that they are very used to dealing with disputes. So it really depends on the level of sophistication of the actual client.
No, that makes complete sense.
And I was going to say also, and add in that, there are sort of challenging aspects, I dare say, with both. I mean, I've acted for insurers for a large part of my career as well, and one of the challenging aspects I find is, as a solicitor, is the discovery process. There's mountains and mountains of documents for insurers, as opposed to probably the insureds. But do you find in your, maybe to Vic, with as a barrister, do you have any, or do you find a more challenging aspects acting for either or both, or is it pretty much the same?
No, I think it's relatively similar. I think, as Gabi was saying, I think the substance of the advice, it is what it is. The advice, and it doesn't change regardless of who your client is. You're there to express a view as to how you think a policy is going to be interpreted, or whether there's coverage or not. The process can be quite different, and obviously for policyholders, it's very deeply personal, and that's a really can be a significant difference. Not always. There's also very big organisations that are also policyholders that it's a little bit different. It's a bit more of a commercial thing, but for a lot of policyholders, it's very deeply personal, and so there's a sensitivity that you've got to apply when you're sort of understanding it from their perspective, and sometimes that does mean just spending more time sort of understanding and explaining and all of that. So there's definitely there's a different sort of style I think you have to bring, or depending on who your client is,
and that just makes you both exceptional barristers, and that's I think part of, we see it as an honour when we're acting for a policyholder because of that very reason, that it is deeply personal. But one of the biggest roles that we have, and what we do that I think can often be overlooked as a solicitor, as distinct from barrister, is that we are collating the legal team. We are connecting our client with the right advocates, and including the barristers, but also experts, because often these sorts of insurance cases will require independent expert material, and it can be so intricate, the type of business that they're in, and we need to ensure that we have the right expert for any given case. Just on that, Gabi, could you just talk us through at a high level the sorts of experts that you tend to see in insurance cases?
Sure. So at a very high level, you might have technical experts who are dealing with liability, that is the liability of the insurer to grant cover. And you might also have what are called quantum experts, which are experts who actually calculate how much the insurer might be liable to pay out if cover is found to issue. So that's at a very high level. And then say, for example, in a let's say, for example, a house fire scenario, you might have an expert report from a fire engineer, for example. You might have an expert report from a loss assessor. You might have an expert report from a building consultant. You might have a report from a building surveyor, depending on scenarios. It's really fact dependent. It's absolutely fact dependent. In a life insurance context, for example, you might need expert evidence from a financial services provider. You might need expert from a medical professional.
No, that's very helpful.
No, there's a lot of experts, I think, and I think that's one of the things that I think policyholders might not appreciate is, you've got potentially your legal team, and then you've got your sort of the experts as well, and sort of that trying to find the right experts or engage in the right experts to assist everyone is part of the job, so to speak.
It is, and as long as listeners understand that you're not left alone. If you go to a solicitor, your solicitor will assist in that process, and you ultimately, you as the client, have the ultimate decision making. But that's what your solicitors are there to assist with and to help support, is gathering everyone, as Danielle said, gathering everyone, the whole team together to present the case as efficiently as possible, but with the most impact.
And that's a great segue. I might ask of both of you actually this question, which is what one piece of advice you would give to a policyholder who might be facing an insurance dispute right now? What's one sort of one tip that you would give?
I've got something in my mind before the dispute. Like,
sure,
if maybe I'll give that one because I had this in my mind to talk about, which is when you're taking out cover, or before you change cover, always think about what that means
good one.
to you. I find that most of the not most, I'd say around 50% of the things that I see are situations where a policyholder has fallen between two policies. And they usually find themselves in that situation because they've changed, and this can happen in any circumstance, whether that's a life TPD setting. For professionals, it's, someone that's changed their professional indemnity insurance provider, and they find themselves in a situation where they're in between two policies, and each one can decline for a different reason, and it can be a very, very difficult situation. And I know that it's really appealing to think, oh, I can get a better deal here. I'm going to change policies. And sometimes that is absolutely the right thing to do. But I suppose my caution is, have a think about what that means. If you had, for example, a policy that had the benefit of a continuous cover clause and you're going to move to one that doesn't, that might be fine if there's absolutely nothing that you've got to be concerned about. But if you've even got a niggling thought about something that might eventuate, even a low possibility, but switching policies might not be the right thing to do at that point in time. So that's one particular point in your life as a policyholder to be really, really cautious, really think about it, get advice at that point.
Would that be from an insurance broker?
Yeah, you could from an insurance broker, but even, you could see a solicitor too to get advice at that point, and to say, look, I find myself, I'm looking to switch. This is the policy that's available. But by the way, I've got this issue that's been around for a while. Nothing's happened with it. Do I need to be worried? And you might get advice about, for example, notification of circumstances under the Insurance Contracts Act, or things that you can do to protect yourself before you switch. So I always think the best protection a policyholder has is what they do before they get into the policy. And so I would really think, and that's one of those points in time that I really see things often come unstuck, and people find themselves then, because it's very difficult after the fact to solve that problem once you've not notified, for example, of a claim under one policy, but you've taken out a new one. You don't have continuous cover. There's good reasons why both insurers are declining, and you as a policyholder are sitting there going, but I've had insurance this whole time. What have I done wrong? And you've not done anything wrong, but it's that choice of switching at a particular time that can sometimes be really costly. So that's probably my big message to policyholders, to really think about that.
That is such great advice, Victoria. Thank you. That's very good. And Gabi, your one tip?
I mean, that is absolutely, I have also seen a number of instances of policyholders who have changed cover, wanted to pay less in premium, premium being what the policyholder pays for the risk that the insurer takes on, wanting to reduce the amount they are paying for whatever reason. Say, for example, professional indemnity insurance, or I've even seen income protection insurance, trauma insurance, wanting to just reduce cover, and then of course, in the policy that they've then walked into, more exclusions, and of course the very thing that becomes the subject of the claim is the thing that is excluded under the subsequent policy. Now, you can't necessarily, no one has a crystal ball, and if we did, we probably wouldn't have an insurance industry.
Yeah.
But it is important, for example, if you're looking at an income protection policy and you're going over your finances and you think, I am paying way too much for my income protection policy, I am going to go to a less expensive policy. Okay, it doesn't cover particular heart conditions, and even heart events, so cardiac events, for example. And you think, well, that's fine because I'm whatever, say you're 43 and you think you're fit and healthy, but you're making a decision. And I'm not giving any financial advice to any listeners about being 43 taking particular kinds of cover. I'm just saying being aware of, very, very aware of what you're buying when you're buying a policy, when you're paying your premium, be aware of what's in and what's out. And that comes back to what we were talking about at the beginning. Read the document if you if reading the document makes you want to cry.
Most of them do.
Most of them do. Take it to someone who isn't going to cry and who will explain to you what you're getting and what you're not getting.
That's great. Thank you to both of you. It's been wonderful.
Pleasure.
Yeah, thank you so much for coming today.
Thank you for having us.
Thanks for having us.